Hello, good evening, participant. Thank you very much for joining. So, sir will be joining in 5 minutes. Hello, good evening, sir. Namaskar, sir. One second, sir. I am making you co-host.
Unmute me.
Hello, good evening, sir. Namaskar. Thank you, sir,
Good
for
evening, good
joining.
evening. Yeah,
Yeah,
thank you.
shall we start, sir?
Yes, yes.
Okay. Dr. Somnath, over to you.
A very good evening to each and everyone present. Today, we are on the fourth day of the National Capacity Building Program on Disability Laws organized by Pro Bono India and Center for Disability Studies, GNLU, Gandhinagar, Gujarat. We are lucky enough, we are privileged to have today as resource person Professor Dr. Sanjay Jain, who is presently teaching as professor in the National Law School of India University, Bengaluru. Sir is having a teaching experience of more than 25 years, and he has taught in different universities as well as in different law colleges. Sir is having a passion on disability laws. Sir has been awarded several awards by the President of the country. Sir has contributed as author of certain books and has edited books. He has contributed articles in edited books even. Along with that, he has several articles in different peer-reviewed reputed journals. And today, Sir will be delivering on relating to education and employment under the RPWD Act of 2016. Therefore, we all are waiting eagerly to hear Sir. So, thank you, sir. Welcome, sir. You are most welcome in the program today. Sir, you may start.
Yeah, thank you very much for that lovely introduction. I'm always happy to be associated with GNLU and their collaborators, and it's a very fruitful, stimulating, intellectually satisfying journey I'm having with GNLU and colleagues like Maurice Port or Mr. Gupta. It's always pleasure to work with such good colleagues. And I'm also happy that every year GNLU makes it happen. A program or a course or something on disability keeps on happening. And this, I think, makes GNLU exceptional because, generally law schools are identified with corporate culture, but Madhav Menon, when he established law schools, first law school when he was established, it was established by him. His vision was to prepare social engineers. His vision was that products of such law schools should be able to identify the vulnerable sections and try and help them address their concerns. And I don't think this vision, which was one of the cherished ideals of law schools, is followed across India. Very few law schools take that vision seriously, and I think JNLU is doing that. So I'm also happy that I think they are getting support from their organization for doing such good programs. Having said that, today I'm supposed to speak on two very important areas in RPWD Act. Rights of Persons with Disability Act, and those areas are education and employment. Both are very important areas. A word about RPWD Act briefly. RPWD Act is a step forward by Parliament as part of India's commitment to United Nations Convention on Rights of Persons with Disability, because India ratified the convention in 2007, I believe, and in 2008, the convention came into force. It entered into force. So from 2008 to around 2016, it was a long journey, and ultimately the disability community was able to convince the government and the legislature to enact this important law. And I believe that when you look at the size of India and the claims of different communities over the time of the legislature, then it is really miracle, because in 1995, the first law was enacted, the Persons with Disabilities Act, 1995. It took 45 long years for us to have a law after independence. But in less than 25 years, I think, less than 25 years, we were able to get a revised legislation. So by no means it is a small feat. And therefore we should be all grateful to the activists, to the organizations, civil society members who worked very hard for getting this law passed. We should also thank Sudha Call Committee, and I think some of us might have also attended some sessions, some consultation programs under the auspices of that committee. So let's briefly look at the approach. Was there any transformation in the approach of the legislature when this law was enacted? Because this understanding would help us to take the discussion forward. So indeed, there was a big transformation, because the main thrust of the UNCRPT was to abandon medical model and to look at disability not purely as a medical reason, not purely as a medical phenomenon, but as a social phenomenon as well. So socio-psycho medico model, one can say. It's a socio-psycho-bio or socio-psycho-medico model. So why medico? Still, because we still talk about long-term disability. So our focus is still on the body. Our focus still is not merely on barriers, but the impairments. And I think rightly so, because I don't believe that you can merely focus on barriers and exclude impairments and merely argue that, okay, social model of disability is the key. No. Alongside social model, which focuses on the externality, which harps on disability being manifestation of the external barriers, I think sometimes impairments also lead to limitations, and impairments have its own implications. So my impairment as of blindness has its own issues, and one cannot merely look at the external barriers while addressing blindness. You have to also address the pain associated with impairment, the fatigue associated with impairment. So therefore, I think we should not be exclusive in choosing the pathway. And in my opinion, we need to focus equally on impairment as well as on the barriers on disability. So this so-called watertight distinction between impairment and disability, I think, is not very helpful. There is impairment in disability, and there is disability in impairment. Having said that, how the law uh, works in the domain of education and employment. So first of all, if you look at the title of the chapters, certain chapters, they are under the rubric of rights and entitlement. Rights and entitlement. So is there any difference between rights and entitlement? Generally, rights are negative. Rights are uh, recognized to also recognize freedom, autonomy. So rights would involve non-interference on part of the state, inaction on part of the state, or neutrality on part of the state, and would enable the individual on whom the rights are conferred to be active, to be engaging, to be to be assertive. So when we talk about rights, we are talking about it's a bilateral relationship mostly between the state and the subjects. But on the other hand, when we talk about entitlements, entitlements are different from rights. Mostly one can equate entitlements with socio-economic rights, the rights of what may be generally termed as the second generation rights, social rights or positive rights. Now, these social rights or positive rights, they are not limitations. Rather, such entitlements or rights for their success dependent on the programs and schemes. And many times such rights duty based. That way, even the negative rights are also duty based, but the duties imposed on the state under by the social rights, they are positive duties, duties involving concrete action, duties involving allocation of resources. So therefore, when we look at the two chapters I am assigning, both these chapters are more uh, they are more assignment than it's, and for the attainment of these assignments, there is fair amount of dependency on the state. So, for example, let's look at the provisions, some of the interesting provisions of these two chapters. I will first go into education. Talking about education, let me to begin with say that education is the way towards light. It's opposite of uh, darkness. It enlightens us. Now, when I using the word enlightens, not in the sense of uh, light, I'm saying enlighten in the sense of knowledge. So if you want to acquire knowledge, if you want to acquire knowledge, or if you want to mm, um, enjoy intrinsic pleasure of learning anything, knowing anything, then it is important that you 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 ought to have education. So education is an enabler, right? Education is a domain. Once you are in it, and you are in many other domains, so it's a enabling, right? It's an enabler. So how this right is structured in this particular in this particular act. So First of all, Section 16, if you look at Section 16 of the RPWD Act, it talks about the duty of educational institutions. So a duty is cast on the educational institution, and this is a very important duty. The appropriate government and the local authorities are under duty to and these institutions may be institutions which are funded by the government or local authorities, or even if they are recognized by the appropriate government or local authorities. Appropriate government means the central government or the state government or the local authorities. Such uh, such institutions are under the duty uh, to provide inclusive education to the children with disabilities, and towards that end has to take certain measures. So it's a very interesting language. The duty is cast uh, on the state for in providing to catering inclusive uh, education, and strangely, the term inclusive education uh, is not elaborated, is not defined anywhere. Rather, you have to go to subclause M, section 2, for uh, uh, throwing light on the term inclusive education. So, inclusive education means a system of education wherein students with and without disability learn together, and the system of teaching and learning is suitably adapted to meet the learning needs of different learning needs of different types of students with disabilities. Now, this is a very interesting definition. Inclusive education is understood to mean that the able-bodied and disabled students must be able to study together, and number two, that we should adapt the system of teaching learning in such a manner that it becomes suitable to meet the learning needs of different types of students with disabilities. So when it comes to adaptation, the definition says that adaptation is required for meeting the needs of the different types of disabled students. So as if when inclusive education is catered, adaptation is not required for the integration of inclusion. Integration is not required for creation of inclusive environment. The adaptation is required merely to tailor the curriculum to meet the different needs of the disabled students. So as if the curriculum is suitable for the able-bodied students, and it needs to be made. It needs to be made suitable by tailoring it with the different needs of the different kinds of students with disabilities, different types of students with disabilities. In my opinion, this is a very problematic definition, and it operates on the assumption that uh, you do not require any major adaptation if you want to allow the children with disabilities and children with able body to study together. It's possible, as if you have to just make some physical infrastructure available, and that's it. Only thing you have to do is you have to just adapt the curriculum to meet the needs of different types of disabled students. Now, I believe that when there is a interaction between disabled and non-disabled students? Can non-disabled students cope this interaction without sensitization, without some amount of acquaintance with disabilities? So this superimposition, the superimposed assumption on the non-disabled students that they can cope, and the assumption that the students with disabilities are at receiving end, they are the ones uh, whose needs the design of the education, the current design of the education cannot meet, and therefore we need adaptation, I think is deeply problematic. A, for coming together of disabled and non-disabled students also you need adaptations, and B, to address the different needs of people with disabilities, students with disabilities also, you need uh, you need uh, you need adaptation. Now it is another interesting issue with which needs to be addressed is who is the unit of this right, to whom this right is addressed. We are talking about inclusive education, and therefore who is the unit for the exercise of this right? And the law says, at least when you look at 16.1, section 16, clause 1, it it adopts children as the unit of the rights, which is very strange. How can only children be the unit of this right? There may be two explanations. One, if you provide inclusive education to children, automatically they will be rehabilitated, and then you won't require any inclusive education in higher educational institutions. But this is a very childish and simplistic assumption. You need inclusive education duties not only on the primary and secondary schools, but also on the higher education institutions catering to the higher education domain. So working in the higher education domain. So it's very strange that the unit of the right of higher education, right of inclusive education is children. However, when you look at the definition of inclusive education, it talks about the different types of students with disabilities. Now, when you try and distinguish between children with disabilities and students with disabilities, definitely there is a issue of there is some relevance, because student with disability may not necessarily belong only to school, but he may also belong to colleges and universities as well. So this is a strange paradox between the definition and the law, the substantive law, section 16. Now, what are the duties? Just we'll illustratively see few duties. So first duty is admit them. And them means the students with disabilities, and in this case, the children with disabilities, discrimination, and provide education and opportunities for sports and recreation activities equally with others. So one of the elements according to RPWD Act, according to legislature, is providing for sports and recreation, and it should be provided. So one of the elements, if you are able to have sports and recreation facilities in schools, and if they are provided equally to disabled children, you are contributing towards making the education inclusive. Make building, campus, and various facilities accessible. Provide education, and opportunities for sports and recreation. Equally with others. So one of the elements according to RPWD Act, according to legislature, is providing for sports and recreation facilities in schools, and if they are provided equally to disabled children, you are contributing towards making the education inclusive. Make building, campus, and areas provide reasonable accommodation according to the individuals. And now this is very interesting. Here again the terminology change. Now we are not talking about children. Now we are talking about individuals' requirements. So where is the focus of the law? Whether law wants to cater to children or whether law wants to cater to individuals. Can we say, for example, that with regard to the duty to provide admissions without non-discrimination, the law is a law regards its unit as individuals, whereas when it comes to duties like duty to create environment for sports and recreation, we are talking about children. It's difficult. Why the legislature is using different terminology? Because in the courts, such terminology may create problem. Now, provide necessary, next duty, very interesting, provide necessary support, individualized or otherwise, in environments that maximize or maximizes academic and social developments consistent with goal of full inclusion. Now, when this duty is cast in terms of individualized support, separate special measures, we don't know who are the units because it's not addressed. The subject of the duty is not made clear. Ensure that education to persons. Now here, look, the word person has come. So now we have individual, we have children, then now we are person. Ensure that the education to persons who are also who are blind. Sorry, education to persons. Ensure education to persons who are blind or deaf or both, and both is imparted in the most appropriate languages, and modes and means of communication. Now, it's very interesting. Again, this is very interesting because now we are focusing on particular disabilities. From general disabilities, we have all of a sudden jumped on two distinct disabilities, blind or deaf. With regard to deaf, I can understand languages, but why with regard to the blind, they are talking about languages or modes and means of communication, because blinds do not have the communication issues. So again, it's a problem of category error because what is happening is we are trying to paint blind and deaf with same brush. Detect specific learning, and this is horrible. This next one, detect specific learning disabilities in children at the earliest and take suitable pedagogic and other measures to overcome them. How can you overcome disability? Law is not supposed to overcome disability. How can something which is acquired be overcome? Right? It's a cliche. Generally, people say, okay, no, you have achieved so much that you have overcome your disability, which is a complete misrepresentation, because I can't overcome my blindness. Nobody can overcome his or her disability. And here, law is suggesting that the learning disability be overcome. And the most objectionable thing is not only pedagogical but other measures. So what other measures? I mean, educational institutions, they are expert in pedagogy. So beyond pedagogy, what other measures they would take to ensure that children overcome their disability? Do we want to banish them from the schools? I mean, what exactly is the intention of the legislature. Monitor participation. This is another very hierarchically worded provision, very paternalistic provision. Monitor participation progress. Participation progress. And there is a comma after participation. I don't know why. There is a participation, comma, progress. It doesn't make any sense. In terms of attainment levels and completion of education in respect of every student with disability. Now, fourth unit. Now, we are also talking about, so it's everywhere. The law is simply, it's indiscriminate use of terminology. Student, children, individual, person, right? So we really don't know what is the focus. And this is very interesting. Monitor participation, comma, I don't know why, progress in terms of attainment of levels of completion of education in respect of children with disabilities. So you grade the children in terms of how they complete the grades, how they complete, how they progress from one class to another. But what purpose it would serve? I mean, monitor participation progress, and merely by succeeding in passing, can we say that it is a successful participation? For successful participation, you require many other criteria. Then provide transportation all of a sudden from the micro level. Now we are talking about the concrete things. So we are talking about now, it's a meso kind of a thing. So provide transportation facilities to the children with disabilities and also the attendants of the children with disabilities having high support needs. Now, whether it should be provided cost, not clear. Now, section 17, which became a very important section in the famous decision of the Supreme Court, in which case the reasonable accommodation judgment. Can anybody tell me the famous judgment of the Supreme Court in which Justice Chandrachud talked about reasonable accommodation recently? Am I audible, sir?
Yes, 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 yes. Participant, any response from your side?
Yeah, any
Please respond to that.
response? The judgment, famous judgment of the Supreme Court, UPSC judgment, the judgment
Pragya
which
Pasun,
was
sir.
there.
Pragya Pasun. Vikas Pragya Pasun.
No, Pragya Pasun is on the accessibility. It's a kind of a judgment.
Salman Khan, over to you, Salman Khan.
Anybody? Yeah.
Vikas Kumar judgment.
Yeah, Vikas Kumar. Correct. So the Vikas, with the age, you know, this is another disability. You tend to forget the names. I am now 56. So basically, and I'm grateful to Mr. Chandrachud for having cited my scholarship in that judgment. So in that judgment, the court used some of section 17. Now, section 17 is very important, and it talks about the appropriate government and the local authorities shall take the following measures for the purpose of section 16, namely. So again, this is a tailpiece to, this section is a tailpiece to, or this section is dotted around section 17. And some of the duties are very interesting: to conduct survey of school going children in every 5 years, for identifying children with disabilities. Again, we are talking about children with disabilities, ascertaining their special needs and the extent to which these are being met. So we are not very much focused on their inclusion, but we want to ensure that whether their special needs are met. And it's also not clear why we should survey only the schools, probably because right to free and compulsory education is confined till the age of uh, 16 or 18, I think, for the children with disabilities. Provided that the first survey, okay, that's not very important, to establish adequate number of teacher training institutions, then to train and employ teachers, including teachers with disabilities, then to train professionals and staff to support inclusive education at all levels of school education. Again, no focus on higher education, no focus on even secondary education, to establish adequate number of resource centers, support educational institutions at all levels of school education, again, to promote the use of appropriate augmentative and alternative modes, including means and formats of communication, braille and uh, sign language, to supplement the use of one's own speech to fulfill the daily communication needs of persons with speech communication or language disabilities, and enable them. It should be enable. Now it's written enable them to participate to contribute to their community and society. So here we are talking about persons with disabilities. So again, there is a jump from the school to person. So again, certain duties are regarding schools, and all of a sudden we are talking about persons. To provide books, this is to provide books, other learning materials, and appropriate assistive devices to students with benchmark disabilities, free of cost up to the age of 18 years. Now, it is very strange that despite a separate chapter despite a dedicated chapter on the theme of benchmark disability, all of a sudden, from nowhere, from almost blue, this reference to benchmark disability crops up. And this duty is confined only to benchmark disabilities, which is a drafting anomaly. It's a odd man out kind of a situation. Then H, which was I think the section by Justice Chandrachud, to provide, no, I think I, if I'm right, to provide scholarships in appropriate cases to students with benchmark disability, all of a sudden. And then I is very interesting, to make suitable modifications in the curriculum and examination system to meet the needs of students with disabilities. Again, here students with disabilities, such as extra time for completion of examination paper, facility of scribe or amniosis, uh, exemption from exemption from second and third languages uh, courses, third language, exemption from second and third language courses. Now, all of a sudden, again, benchmark disability disappears and the nomenclature of student with disability comes into being. And luckily, because there was no benchmark disability, Vikas Kumar could get relief. So it's in a sense accidental also. It's not clear why uh, uh, some duties are confined to benchmark student with people with benchmark disability. Some are generic duties to promote research, to learning, and any other measures as may be required. So now there is one very important aspect which I forgot. I mean, now they say exemption from second and third language courses. Why exemption? There was a time when we would get exemption from maths and science, and we would do something which we have already done in 8th standard in 10th standard. And then if we score good marks, then people will say, okay, arey, inka kya hai? They are getting good marks because they are doing the same subjects again and again. So clearly, this is a paternalism of highest level. And again, it's kind of shirking of responsibility. Why? You want to give second and third language courses exemption to everybody. Okay, to some disabilities you consider, particularly speech impaired people with hard of hearing. But why blind people should get exemption from second and third languages? So basically, when you look at this law, when you look at these two sections, you clearly find that this law is something like preparation of tick boxes, and then just to supply contents to fill those boxes. Very haphazard, very unstructured, and without any ideology, without any normativity, or without any rationale, right? So very unfortunately worded provision, and I want to undertake some exercise. I want to undertake some discourse. I want to do some study using discourse analysis. How unsuited language or thoughtless language uh, can have its impact on law. The next chapter I'm supposed to do is it's known as skill development and employment. So Modi ji is India, so Modi ji wants everybody to be independent, self-reliant, and he has his pet terminology of Divyangjan for the disabled. So, okay, we are unethereal, extraordinary people. So, we should be extraordinarily then skillful, etc. So, that's skill development and employment. And section 19 talks about vocational training and self-employment. There is a Skill India Council, and that Skill India Council, I think, does some work for the people with disabilities as well. I'm not much aware of its work. If anybody knows, I would love to hear. But my focus would be on some other provisions, because this section 19 is merely exhortative. Again, we should do that. We should do this. We should do that. Now, non-discrimination in employment, section 20. And Ravindra Dhariwal is a very important judgment which used section 20 to its very highest potential, in my opinion. And I would like to focus on this particular section. This is a very important section. And despite the definition of discrimination in RPWD Act, there is a specific non-discrimination provision in the employment chapter. So this is something which is really a silver line in darkness, because otherwise most of the provisions have this or that issue, but this provision seems to be a very good provision. So what it says: no government establishment shall discriminate against any person with disability in any matter relating to employment, provided that the appropriate government may, having regard to the type of work carried on in any establishment, by notification and subject to such conditions, if any, exempt any establishment from and from the provisions of this section. Now, although I salute this provision for recognizing the right of non-discrimination of people with disabilities on the ground of disability, nobody should be discriminated on the ground of disability. But at the same time, what the what the what the section is saying, it is also saying that okay, a blanket exemption can be provided to any establishment from the provisions of this section. Of course, the provision, the exemption should be maybe provided by notification subject to such conditions, if any. So, question arises, if, for example, disability was one of the grounds of non-discrimination in the Constitution, would you have provided such exemption? And I believe why establishments need exemption from non-discrimination provisions. They may need exemption from maybe reservations. They may need exemption uh, uh, to provide that okay, the particular establishment is not suitable for the disabled. I mean, you can think in terms of those lines, but why there should be exemption from the non-discrimination provision? Then every government establishment shall, and this, who would provide the exemption, on whose recommendation the exemption would be provided, is not made clear, right? Just a minute. Yeah. Then so it is not clear how the exemption will operate. What is the procedure? Whether the government should consult CCPD? Nothing. Every government establishment shall provide reasonable accommodation and appropriate barrier-free and conducive environment to employees with disabilities. But what if they don't provide? Is there any consequence for non-compliance of this provision? No uh, consequence. For example, there is nothing like the institutions will be fined or the penalty will be imposed. Nothing. No promotion shall be denied to a person merely on the ground of disability. So merely on the ground of disability is again another problem, because if you are able to show that there is a disability plus ground, then you can deny promotion. So okay, he is disabled and he is somewhat less efficient. So you make certain remarks in my appraisal, make me look less efficient, and then it will not be a denial of promotion merely on the ground of disability. No government establishment shall dispense with or reduce in rank an employee who acquires a disability during his or her employment. Now, this is a normal provision. If you acquire disability in service, you should not be fired. You should be given an alternative employment. And in fact, this is a section which is usually uh, applied to the non-disabled who become disabled, and therefore you would find most number of cases under the PWD Act and RPWD Act revolving around this section. And then there is also the exemption. Now this is very interesting. Provided further that if it is not possible, yeah, the supernumerary posts can also be created. And then the appropriate government may frame policies and post may frame policies for posting and transfer of employees with disabilities. But what happens? What happens if policies are not framed? Again, no consequences. And may, the word may is used so very feebly worded obligation. Then there is a scope for equal opportunity policy. There is a provision which says every establishment shall notify equal opportunity policies detailing measures proposed to be taken by it in pursuance of the provisions of this chapter in the manner as may be prescribed by the central government. Again, a very badly worded provision. Why central government should prescribe the guidelines? Equal opportunity policy is specific to the environment of an establishment, and therefore the establishment is the uh, uh, best entity to decide its own policy, because the best alibi would be otherwise. Okay, central government has not provided guidance, so how we would frame the equal opportunity policies? And at any rate, this is a very top-down approach. Why everything must come from Delhi? Then every establishment shall register. Every establishment shall register a copy of the said policy for the chief commissioner, or just a minute, I will read this again. Every establishment shall register a copy of the said policy for the chief commissioner or the state commissioner, as the case may be. Now, this is curious. If the policy is to be made based on the guidelines of the central government, the competent authority must be CBP. But what is mentioned is, okay, you go by the central government guidelines, but depending upon where you are located, your authority will be determined. But where are the state commissioners? Have you appointed state commissioners? And by the way, where is the CCPD? The Babu bureaucrat right now is the CCPD, the secretary level person who has definite bias towards government. So where is the secretary? Where is the commissioner? And where is the CCPD? So already we have poured water on the provision by not implanting the necessary machinery. Then maintenance of record, a very useful provision. Every establishment shall maintain records of the persons with disabilities in relation to the matter of employment facilities provided and other necessary information in compliance with the provisions of this chapter in such form and manner as may be prescribed by the central government. Again, why central government should prescribe the format? Because again, the alibi will be, okay, we are not able to maintain record because central government has not prescribed format. Why, for example, central government's format is required to maintain record in say Baroda or Ahmedabad? Why GNLU is not good enough, for example, to have its own pro forma? Why you need central government? Again, top-down approach. Again, the typical Delhi approach. Every employment exchange shall maintain records of persons with disabilities seeking employment. Again, but where are the employment exchanges now with privatization? Again, a very colonial stuff, because more than employment exchanges, I think the placement cells of every college, every universities must be now, and the district collectors, they should be asked to maintain, because the employment exchange culture is almost over. The records maintained under subsection 2, subsection 2, 1, sorry, shall be open to inspection at all reasonable. Again, what is the use of this clause? Because where are the guidelines of the central government to maintain the record? I have not at least seen the guidelines. Anybody can enlighten me if there are any guidelines. Then appointment of grievance redressal officers. Where are these officers? So I remember Amartya Sen's article, where are women gone? So where are the redressal officers, grievance redressal officers? So again, a paper type. And what this provision says, yeah, every government establishment shall appoint a grievance redressal officer for the purpose of section 19 and shall inform the chief commissioner or the state commissioner, as the case may be, about the appointment of such officer. Okay, what next? Any person aggrieved with the non-compliance of the provisions of section 20. Why section 20 alone? God knows. Section 20 may file a complaint with the grievance redressal officer, and he will take up the complaint. The grievance redressal officer shall maintain a register, again a babu work. Again, if the aggrieved person is not satisfied with the action taken on his or her complaint, he or she may approach the district level committee on disability. Where is the district level committee, by the way? How many district level committees have been established? And what should be the who is, what are the qualifications, by the way, of grievance redressal officers? Mostly, the head of the departments would appoint grievance redressal officers, such persons who are very close to them, so that there are no complaints. And even if there are complaints, leads would be put on those complaints. So, friends, this is what is mentioned in these two chapters, employment and education. It's not my nature to be just reading those provisions. So, as always, I've had my critical take on these provisions. Uh, uh, I would like to briefly look at the definition of discrimination, because section 20 talks about non-discrimination on the ground of disability. So I will quickly look at the definition. First of all, just a minute. Uh, can somebody help me to locate the definition of disability?
One second, second.
Yeah, if somebody can read the definition, I'm trying to search.
Yes, any participant would like to volunteer by the time
Yeah,
I search?
please. Yeah, quickly. Yeah. Yeah, the definition.
Yes, I'm just searching. I have just opened PDF. Any participant like to?
Yeah, I think it's just round the corner, but yeah. I would like to read, first of all, clause 3 of section 3. No person with disabilities shall be discriminated on the ground of disability. So this is a general non-discrimination provision unless it is shown that the impugned act or omission is a proportionate measure for achieving a legitimate aim. So can there be a legitimate aim which you will accomplish by discriminating with disability? It's an oxymoron. But this section is there, and despite repeated requests from the UNCRPD committee, the government of India has not made any comment and provided any explanation. And this particular section is retained as part of the law. Yes. So
Yes,
whether anybody is able to
Ruby.
find the definition?
Yes, Ruby madam.
Yeah.
Yes, sir, good
Mohammad
evening.
Sareem.
Yeah.
Yes,
Yes,
sir,
madam.
Sanjay sir,
You
good
are raising.
evening.
Yeah.
Highly
Please read.
commendable deliberations. Highly
Yeah.
commendable deliberations. God
Yeah.
bless you. Sir, it may be, this disability may be inborn also.
Yeah.
Yes,
Correct.
it may be inborn, it may be temporary, or it
Yeah.
may be of a permanent nature.
Yeah.
And which can, some disabilities are overcome and
Yes.
treatment is there. But
Yeah.
some are which are permanent inbuilt by birth, they cannot be.
Yes. But there is a definition of disability-based discrimination in the law, which
Yes,
I
Yes,
sir.
sir.
Section 2H discrimination have been mentioned, but they have not
2H.
defined what is
Sorry. Can somebody read
disability, sir.
2H? Yeah, 2H. Correct. Correct. Correct.
Yes, 2H. They have not defined what is disability, sir. So
That's what I wanted to say. Thank
yes,
you,
sir.
They
sir.
have defined. They have not defined what is disability. They have defined impairments, but that's not my topic. Otherwise, I would have
Definitely, sir.
Yeah.
Sir, just
like.
reading out.
Yeah.
Discrimination in relation to disability means any distinction, exclusion, restriction on the basis of disability,
Yeah.
which is the purpose or effect of impairing of nullifying the recognition, enjoyment, or exercise on an equal basis with others of all human
Yeah.
rights and fundamental freedom in the political, economic, social, cultural, civil, or any other field, and includes all forms of discrimination and denial of reasonable accommodation.
So
Over to you, sir.
exclusion, restriction, and what is the third one?
One, sir.
Yeah. Sorry.
Restriction on the basis of disability, which is the
Exclusion,
purpose.
distinction, and restriction, right? So
Yes, sir.
when
Yes, sir.
you do that, yeah, I got it. Discrimination in relation to disability means any distinction, exclusion, restriction, or restriction on the basis of disability. So when you are restricted, when you are distinguished, when there is a exclusion on the ground of disability, in my opinion, per se, it should amount to disability-based discrimination. But the definition is instrumental. So why instrumental? Because the exclusion, restriction, or the exclusion, distinction, exclusion, or restriction must lead to denial of fundamental rights, human rights in political, civil, economic, etc., domain, etc., and they should cause impediments to enjoy these rights equally in the way of people with disabilities. And what is most important is denial of reasonable accommodation is also part of discrimination. So if reasonable accommodation is not provided to you, it is a clear case of disability-based discrimination. So when section 20 talks about discrimination on the ground of disability, you need to connect it with section 2H and section 3, subclause 3 of RPWD Act. So I don't know whether I've taken more time, but
No,
I've
sir, sir,
tried my
definitely, sir.
level best to stick to the mandate of my talk. I'm not deliberately gone into the case laws, but if there are any questions, I would be very happy.
Thank you, sir, very much, sir, for your great deliberation insight. Participant will be taking only one question because we are running short of time.
Yeah.
Anyone, you can raise your hand. We will take up only one question. Okay, nobody's there. So let me ask sir one question. Sir, we can see a lot of judgment coming from the Supreme Court. So what's the effectiveness of judgment from the High Court related to enforcement of this RPW Act and other rules regulations? High
High
Courts,
Court.
what they are doing, sir?
High courts have
Usually
also
judgments are
given High courts have also given number of judgments. So, for example, Delhi High Court recently gave a very important judgment dealing with the powers of Commissioner of Disability. And the Delhi High Court held that although the recommendations of the Commissioner of Disability are not binding, uh, using the language of the law, language of the relevant section, the court held that that does not mean that government would undermine the recommendations or government would be irresponsive. So there is a timeline within which government has to give response to the recommendations of the commissioner, and if the response is not given, then court may take cognizance of the same. Besides, I also remember a very interesting judgment of Delhi High Court, uh, very clearly an eye opener to discriminatory bodies like KVS, Kendriya Vidyalaya Sangathan, last year when Rongtaji went to High Court, and the court in no uncertain terms directed the KVS to consider blind people as suitable for the position of principals and teachers. Why? Because these posts are already identified by the central government as well as state governments. Recently, I've heard that recently a notorious directive is issued by the secretary of KVS disqualifying blind people from being considered as principals and teachers. So, in my opinion, if at all such directive is there, this directive is clearly contemptuous, and those who are affected must go to court against such discriminatory directive. Thank you.
Thank you very much. Yeah, Dr. Somnath, over to you.
Yes. Am I audible?
Yes, sir.
Yes.
Yes.
Really a wonderful session, sir. An insightful one. I, on behalf of every participant and each and everyone, would like to convey our heartfelt to you for gifting us such a engaging session, such a knowledgeable session. We are really happy. We are really thankful to you. And we are definitely eagerly waiting for tomorrow's session as well to hear you. So
Thank you.
thank you, sir. Thank you.
Thank you. Thank you very much. Thank you.
Thank you.